Shalom, this is your Ark, Yah is magnified, coming back with another informative video. This video is titled, The Third Party Intervenor. So with that being said, let's get to it. Okay, so now, before I move any further, as you all know, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so now we're going to talk about the third party intervener, okay, which is the child support agency. They are the third party intervener, intervening on your into your private matters. Okay, so now if you and your offspring mom, if you're a male, or your offspring dad, if you are a female, dealing in the private and handling your own issues in private, but the custodial parent want to run down to the agency and ask for services to the third party intervener, and then the third party intervener comes in and intervenes on the behalf of the custodial parent, then you now have to address that intervener. You can't let that third party intervener intervene in something that they really have no interest in, even though they try to claim they do have an interest. So they'll volunteer themselves, for their interest. So because they volunteered themselves to enter into this situation, then they're open ball game, and now they are part of a suit that they voluntarily entered themselves into. By what? By agreeing with the non-custodial parent, by agreeing with the custodial parent. Okay, and they feel as though they both have an interest into your private life, which is far from the truth. So with that being said, let's read the definition for intervener. Now, an intervener is a person who voluntarily interposes in an action or other proceeding with the leave of the court. Right? So now, that's why they'll bring you in first for mediation. That's the first thing they will do, with the agency. And if you can't come into a mediation with them, then they say, okay, now we're going to take you to the court. So they'll bring you to the court to intervene on the behalf of the mom. Because the mom just don't take you straight to the court. No, it's the agency that do all that. Why? Because they have to file motions and to intervene. On what? On the behalf of their interests, which they claim is the offspring, which is really the fictitious entity or the all caps name birth certificate created when the child was born. And if you signed that birth certificate, then they claim that you entered into a contract with them, not knowing that, that's far from the truth. So with that being said, though, we're going to pick this up at intervention, but we're not going to do the international law. You know what I mean? But I do want to show y'all this part, though, because it says right here. Let's pick it up right here. Like I said, they always want to do mediation, right? That's their claim to fame, is mediation. So it says, while mediation always is and is intended to be and to continue peacefully only, it says the intervention between a sovereign and his own subjects is not justified by anything in the international law. So again, like I stated, they always want to have mediation prior to going to court, to make you argue the fact that, you don't want to deal with them. And once you argue that, they'll say, okay, well, since we can't come to an agreement, which automatically try to make you in dishonor, they'll say, okay, now we'll bring you to the court, which gives them recourse to a court now. Why? Because there's a disagreement. And then they know they have, a support magistrate that will reap the benefits from the matter. They will continue to move forward with that situation and bring you down to the court, knowing you're not ready for this situation, and they'll proceed against you because you can't protect your interests, at that time. Because like I said, when most of us first get on this child support thing, we don't know any better. We go in there and we argue a debt that never existed from the beginning, which gives the debt validity. So with that being said, we're going to pick this up in the ecclesiastical law, right? Let's pick this up right here. It says, Hold on, let it get clear. It says, in English ecclesiastical law, the proceedings of a third person who, not being originally a party to the suit or proceedings, but claiming an interest in the subject matter in dispute, in order to protect such interest, interposes claim. So now, the agency who can't make a claim has an agent come to the court to make a claim on the behalf of the agency. What type of nonsense is that? But because, like I stated again, we don't know any better, we'll go in there and argue the most simplest stuff that give them validity to a debt that never existed from the beginning. You see, which automatically puts you in dishonor, and once you're in dishonor, you become the debtor. Always. There's no way around it. That's why I tell the guys that I'm dealing with, stop going in there and arguing. For what? Because you'll become the debtor. You'll become a dishonor, then you'll be the debtor. Ain't no point in going in there arguing a debt that don't exist. Don't give it no validity. Okay? So now, we're going to pick this up at, let's scroll up right here. Since child support is a civil action, let's pick this up at civil law. Top line, guys. Hold on, let me talk about top line. It says, in the civil law, the act by which a third party demands to receive as a party in a suit pending between other persons. So now, when you going back and forth with your child's mom, there is no law, there is no suit at all, right? But the third party intervenor, in order for them to intervene on their behalf, they must have some type of case pending, so they can intervene and file motions and stuff on the behalf of that third party, for they can intervene on behalf of the on the custodial parent dealing with the child support agency. So they would have a say so in the interest of the offspring. So now, when they do these type of things and trying to intervene voluntarily, then they deserve what's going to come to them for butting in to private affairs. Okay? So now, that's why it's important to make sure you all have your ducks in a row. But let's continue. It says, the intervention is made either for the purpose of being joined to the plaintiff and to claim the same thing he does, or some other thing connected with it, or to be joined with the defendant, right? And with him to oppose the claim of the plaintiff, which it is his interest to defeat. You see? So now, a third party is only there for their interest. But if the third party can't prove their interest, which is supposed to be the same interest as the custodial parent, then that means the custodial parent can't prove her interest. So with that being said, they must do what? They must dismiss the case. But we got to go in there and stand on that truth alone. That's more than enough truth alone to get your situation dismissed, and then you can pursue after that third party intervener who intervened in an action that they had nothing to do with, between two private parties. Okay, so now let's go to North Carolina, where we can see how the agency is so slick. They will switch sides. They will intervene for the custodial parent, but if the custodial parent decide to give the non-custodial parent the child, then they'll start to intervene for the non-custodial parent. These people are so flip-flop. But yeah, let's go there. Let's go to North Carolina. We're going to do this one for North Carolina, so let's go. Okay, so as you all can see, we're coming from the North Carolina Department of Health and Human Services, right? So for all my people in North Carolina, get ready, man. Get ready to fight. Y'all got to be ready. You got to know what's going on to defend yourself, and be ready. Have your ducks in a row, man. That's all that matters. If you got your ducks in a row, victory coming. You got to be ready to stand. You got to be willing to fight. If you don't fight, you don't win. Plain and simple, simple and plain. But now, I'm going to show you all that the child support agency is a third party intervener. But not only that, they will intervene on whoever side they will benefit from. So now, if the custodial parent decide with the non-custodial parent to give the seed or the offspring to the non-custodial parent, the agency would then want to attach itself to the former non-custodial parent to come after the former custodial parent, which is crazy. They will do anything to get money and to leech off the situation because they feel as though they want to protect an interest that they have no interest in. You see, they want to protect an interest that they have no interest in. You know what I mean? So keep y'all matters in the private. Handle all situations in the private. You can't go wrong. But let's continue. So let's stroll up. Let's prove this. It says reversal of parental roles, right? Right here. Reversal of parental roles. But we're going to pick this up at the third paragraph where it says sometimes. Right here. It says sometimes. It says sometimes when CSS, which is Child Support Services, has intervened in an existing order. So again, they let you know that they intervene. So they are a third party intervening into a matter that they have no say so in. But because they intervened and we didn't address them intervening, they feel as though, hey, they didn't say nothing. They allowed it to happen, so we're going to continue to intervene. But let's continue. It says the roles of the parties are reversed. The NCP becomes the custodian of the child or children and applies for and receives CSS services. So now, if the NCP becomes the custodial parent, now they want to attach themselves to the non-custodial parent, so they can collect from the previous custodial parent, which is crazy. But let's continue. It says this situation can be handled legally in several ways. CSS could file a motion in the same court to dismiss the agency's prior role as an intervenor plaintiff or defendant and request to join the former NCP as a party to the action. So now, if they was intervening on the custodial parent prior, but now they want to intervene on the plaintiff when he becomes the custodial parent. Come on now, you got to go after the intervener. You know, they intervene into your private affairs. They have no right to be in your private business. You know, you have the right to maintain your private life, man. Get any intervener out of that. You get the intervener out your life, everything will go back to normal, man. But let's continue. It says, as an intervener, plaintiff, or defendant. Then it says CSS could decide to file a new action in the form of a complaint. Now, CSS cannot file a complaint at all because CSS don't have arms, legs, a mouth, anything else to speak. You see? But what they do have is an attorney. So if they have an attorney that's doing all the speaking, then hey, you deal with him who's speaking for the agency. Plain and simple, simple and plain. And that's how you get your matters taken care of. But let's continue. Let's stroll up. We're going to go more to prove that they are the third party intervener who trying to intervene in private affairs. But let's stroll up. And if we don't do anything about this, they're going to continue to intervene. So for my people in North Carolina, this is remedy right here. More remedy. Okay, so as you guys can see, we're picking up from modifications. Oops, let me get that out of there. Right there, modifications of divorce or existing support orders, right? Let's pick this up at the third paragraph where it says 2. Right here, 2. It says to request modification to a divorce or other existing support orders, CSS, who? CSS, guys, must motion the court to intervene. Now, did it say the child's mom must motion the court to intervene? No. It says CSS must motion the court to intervene. Why? Because they are the third party intervener. They're taking all the matters in their hands to try to collect on the interest on a matter that they don't have interest in. But let's continue. It says CSS must motion the court to intervene in the matter on behalf of the party requesting the CSS services. You see? So now they're intervening on the party who's requesting the CSS services, which is most likely the child's mom. So if the child's mom is requesting for the services, then CSS will motion the court to intervene on their behalf. So if they want to intervene on their behalf, then hey, go after him who intervenes. They want to intervene, do they? Hey, give them something to intervene for. You know, I guarantee you start doing things the right way, they'll stop intervening, you know. But let's continue. It says the granting of this motion causes CSS to become an intervener party to the actions for child support. Then it says the CSS attorney represents the agency in this action. So again, if the attorney represents the agency in this action, okay, Mr. Attorney, we got some conversating to do. You see what I mean? So with that being said though, guys, it's right here in the open. The facts gonna be the facts, the truth gonna be the truth, no matter who like it or not. The facts is the facts, man. I'm here to bring those facts. Okay? So now get that third party intervener out your life. This is for all states, not just only North Carolina. North Carolina just throw it in your face, but it's for all states. So again, if you guys need my help, man, hit me up in my email at y'allismagnified@gmail.com. And let's get this ball rolling, man. But not only that though, shouts out to all the guys out there fighting, man, who decided to make in their mind that, hey, it's time to fight back, you know. So for all those in the struggle, keep fighting, man. When you guys get success, let me know, and share it, for everybody can see that, hey, it is remedy out there, more remedy. And I have more remedy to come as well. So with that being said, you all be blessed. Shalom.